this panel on focus on Latin American developments on data protection. 1 year more, the organizers has had the idea to support a panel on Latin America. I want really thank this support. For the last, I think, 4 years has been organized this panel, and we have had with us very prestigious speakers around Latin America. And this year, we will have the chance to enjoy presentations from very relevant speakers from different Latin American countries. First of all, we'll present Briann from Uruguay, later Danilo Doneda, following Pablo Palazzi, Danilo Doneda from Brazil, Pablo Palazzi from Argentina, Ximena Puente from Mexico, and Paulina Silva from Chile. Our speakers come from different fields, most of them lawyers and academics, but we have with us today the chairwoman of the Mexican data DPA, Ximena Puente, for talking, all of them, about different relevant topics, especially focused on technological evolution. We will have the chance to know about this talk, first Internet Constitution adopted in Chile, about the new general data protection law in Mexico after the constitutional reform in 2014, about the new bill on data protection in Chile, and about other news, interesting, very impressive cases in Argentina, Uruguay, and other countries. And without anything more, I will give the floor to Briann from Uruguay.
Shall I? Please. Hello? Hello, good afternoon. I want to thank you very much for making it possible for me to be here. I hope I can say some words that can be of your interest. I was asked to speak about 2 topics. One general overview on Latin American data protection system, and then from my country, Uruguay, what is new from Uruguay. So, time is running, so in what concerns to Latin America, we have 2 types of countries. Those countries who have comprehensive data protection laws, who are Argentina, who passed the law in 2000, Uruguay in 2008, Peru, Costa Rica, Nicaragua, Colombia, and República Dominicana in the period from 2011 to 2013. In what refers to Mexico, Brazil, and Chile, I'm not referring, as we have experts in the table that can say more than I. Just a general overview. From all those countries who have a comprehensive data protection law, only Uruguay and Argentina were declared as countries with an adequate level of data protection according to Directive 9546. And from them, only Uruguay ratified Convention 108, and it came to be, as a consequence of the ratification, the 45th state to become a party of the convention and the first non-European country to do so. Well, said this, there are other Latin American countries who have no data protection comprehensive law. And in these cases, what happens? Well, the constitutions in general of Latin American countries have dispositions that protect the rights inherent to human condition or that derive from the republican form of government in an open way. There are also, in general, sectoral laws for the protection of personal data. Some constitutions also have actions to defend the rights of data protection called habeas data or action on data protection. And that would be all. Now, I'm going to tell you about my country, Uruguay. What is new from Uruguay? No, this is not new from Uruguay. This is old. Just to take it into account, we have the law from 2008, the Declaration of Adequacy of 2012, and 2013, the ratification of Convention 108. So now what's happening nowadays? Some topics, for example, this one, there is a new, from last year, regulation on, for the public sector on domain names. It regulates on the obligation of the public institutions to use domain names .government.uy or mil.uy, and only those one. At the same time comes the prohibition to use other domain names. And there is, in this same regulation, there is the obligation to have all data protection centers in Uruguay. This is speaking on the public sector. Following, also new, a disposition on security incidents and data breaches that follows the general strategy of President Jose Mujica and organizes a third UI depending on AGESIC, which is the agency for e-government in my country. It is in charge of the register, the classify, the diagnosis, acting and informing on data breaches and incidents on security. Even though the disposition is a bit older, the first time that the results have been informed is in last year. Other disposition, speaking on agreements of interoperability. This government we have now has a special interest in what is exchange of information in public and also in private information. In case it is private information, the regulation states that you need to ask for the consent, and the consent has to accomplish with the requirements. That is, it has been given previously in a free way, specifically, and has to be informed. In what concerns to the agreements, they should be registered. There are quite a lot of agreements being made in this, according to this disposition. Another disposition is on free software and open standards. This one is from last year, and it says that free software should be preferred in government offices and that it should be promoted in schools. And open government also should be preferred. It also speaks of the need of standardization according to international parameters. In what concerns more specifically to data protection, there is this disposition that states that every website must publish a privacy policy. And the privacy policy must accomplish with the regulation on data protection. As you can see, all these are new. It is like they are trying to hurry up I don't know why. Well, there's also this regulation that declares that the Uruguayan DPA is acting within its competence when it orders an institution to disclose completely the information requested. This came as a consequence of a case in which some information was requested by the data subject, but it was not given completely, and the DPA ordered the institution to give it, and consequently passed this regulation. This other regulation, and I believe it's the last one, hope you are not too bored, recommends that previously to the publication of data in public websites, issues concerning to data protection should be attended. So, in order to honor the right to be forgotten, in some cases certain data should not be included, and in other cases the data can be erased afterwards, or there should be the possibility of erasing it afterwards. The aim of this disposition is to prevent that data that has been erased remain in the index of searches such as Google, Bing, or Yahoo. That would be all. I'm sorry that this was like a little bit of each, but the idea is to give you just what is due. Just telling you what do I think Latin America data protection system needs, and it's educating, it's generating awareness, imposing more fines, issuing civil and also criminal proceedings, and also working in cooperation, integration, and harmonization. Thank you, and this is my email. Thank you.
Thank you, Anna. And let me ask you a question. You have mentioned that the Uruguay reached the adequacy declaration from the European Commission in 2012. That means there has been 2 years of experience. I don't know if it's possible to have some kind of evaluation of the impact effect if the DPA of Uruguay has some impression about the effect of this recognition by the European Commission. For the moment, just Argentina and Uruguay are the only countries in Latin America which reached this regime, and it would be interesting maybe for others to know. Maybe 2 years is not so much for having this assessment, but can you tell something about?
Yes, I can notice the difference in my country between a previous time and afterwards, after the adequacy. The ways the authority, the DPA, is working, it's more institutional. It has the support of the Spanish agency and of the European authorities. And, well, I can't give you numbers, but you can see more institutionality in the way it is working. In general terms, I don't know if you have a more specific question, but...
The question would be more focused, if you want, in the economic impact of the more easy way to flow data from Europe, especially to Uruguay, establishing outsourcing companies, call centers, more or less what is expected.
I would like to have numbers. I didn't bring them, but in general terms, I can say yes. It was certain companies are appearing and with more work of outsourcing and telephonic data centers. Okay.
Thank you, Anna. And now it's the floor to Danilo from Brazil.
Thank you, Artemi. After the 90s, when data protection legislation expanded through Europe and other countries, Latin America became a kind of a new frontier for the enactment of data protection laws. In fact, since the early year 2000, Argentina enacted its legislation that soon gathered the adequacy from the European Commission. And since then, many other Latin American countries implemented their own data protection legislation. Today, it is possible to look back and observe some patterns that are particular to the region and that can give us perspective to evaluate some new experiments that are being made in the region. One of these patterns is that, for several reasons, the use for data protection legislation in Latin America arrived later than in Europe or other places. And when it arrived, its manifestation did not come from a urge from society, but from the peculiar political landscape. In the 80s, some countries in the region were gradually turning back into democracy after a period of dictatorship. And legal instruments needed to be shaped to help people to gather personal information about them from the state, particularly from law enforcement agencies. This is the first pattern. The most known of these instruments is the habeas data, a writ that gives data owners access to their own data. Habeas data was built into the Brazilian Constitution and marked a second pattern, the mention of the right of privacy or related rights in Latin American constitutions. Maybe there is no coincidence that the discussions about something that some people call an Internet Bill of Rights, which was echoed by several supporters such as the Italian professor Stefano Rodotà, or even the support Tim Berners-Lee gives to a kind of Magna Carta of the Internet, found its first actual embodiment in a recent piece of legislation enacted last year in Brazil, the Brazilian Civil Rights Framework. Portuguese is called the Marco Civil Internet. Marco Civil is a peculiar legislation in at least two ways. First, it aims to regulate Internet, firstly by recognizing the rights of Internet users. That is, it's a legislation about digital rights. And second, its formulation, which started from an open public consultation made precisely in Internet. The environment in the formulation of Marco Civil was not simple. There were several bills which aimed to regulate conducts in Internet by considering generally such conducts as criminal offenses in Brazil, generally in a way that could make it difficult for the average citizen to continue to freely use the Internet. At the time, more than simply reject these propositions, it was decided to overcome them by proposing a new bill, this time a civil bill in opposition to a criminal bill that were being considered, which was precisely the first mention of the Marco Civil of Internet. Other than establish merely a set of sanctions for abuses in Internet, Marco Civil aimed at strengthening Internet users' rights, recognizing the central position of Internet in people's lives and its crescent role in developing democracy and society. After a public debate in Internet in 2009, the bill was sent by the government to the Congress in 2012, and it was finally enacted into law in April 2014 during the meeting Net Mundial of São Paulo. It must be stressed that Marco Civil is not a data protection or privacy law. We're talking about data protection law in general, but Marco Civil does things a bit different. The contents of Marco Civil are generally Internet users' rights. Among them, privacy and data protection. But Marco Civil is not a general data protection law. It doesn't have the tools every data protection legislation have to generally protect its citizens and its data, and is strictly confined to Internet. The set of rights, the most important ones, which Marco Civil states are the right of access to the Internet, freedom of speech, privacy, protection of personal data, network neutrality, and stability, security, and functionality of the network. Besides that, Marco Civil regulates other issues, just as the intervention of third parties and the liability of intermediaries in Internet. Well, between its proposition and enactment, something very relevant happened with strong implications to the final content of Marco Civil, particularly to what concerns privacy and data protection, that were the disclosures made by Edward Snowden. The Snowden revelations had a great impact on Marco Civil. The pressure to introduce and expand its provisions related to privacy and data protections got stronger, and this final text absorbed some tools and instruments which are typical of data protection legislation. Now I'm going to quickly comment on some of these major, most important principles. Firstly, Marco Civil states a series of principles for the use of Internet in Brazil. Two of them are related to our issues, which is the principle of privacy protection and the protection of personal data. But take a look, when Marco Civil talks about the protection of personal data, it states, in the terms of the law, which is Marco Civil, is a red statute which is prepared to recognize future data protection law as another general statute which can regulate in a broad manner data protection. Then we are going to the rights. The user's rights in Internet are stated in the Article 7, and several of them are related to privacy. Firstly, there is a guarantee of the intimacy in private life, the secrecy of communications on the Internet, and the secrecy of the stored private communications. The principle of consent is very strong in the formulation of Marco Civil, even indeed. It's even stronger than in most data protection laws, in the sense that it simply says that personal data will not be shared with third parties except upon the user's free and informed consent, or in cases provided by law, which is other general exception cases that are always found in data protection law doesn't exist in Marco Civil. The purpose principle is more or less mentioned thereafter, when it says that personal data collection can only be used for the purpose that justifies the collection. We have in Marco Civil also a kind of small formulation of a right to be forgotten, which is a formulation that says that upon a user request, personal data must be completely removed. But if you read the whole article, you see that that user request can only happen after the end of an agreement between parties. That is, only in contractual, or only when a contract was made, existed before with the parties, which is that kind of right to be forgotten doesn't apply to general communications and the general more sensitive cases that regards the journalism and practice of communication and freedom of expression. Unlike data protection laws, Marco Civil also comprehends an issue which is related to data protection, but it's not meant to specifically protect privacy, which is Marco Civil has its own regulation regarding data retention, which says that Internet connection providers must keep logs from users for a period of 1 year at minimum. And now, so the Internet application providers, what is an Internet application provider? Is every site, is every service that can be accessed through Internet. When these Internet application providers, when they are commercial, must also keep a log of their use for 6 months at the minimum. That is, Marco Civil was conceived as a kind of reaction to some criminal bills that were intending to regulate Internet. Many of these bills proposed periods of data retention from 1 to even 3 or 5 years. Marco Civil needed to comprehend this demand and ended up including also some provisions regarding data retention. Apart from Marco Civil, there are other developments in Brazil that must be stressed. In the last years, the privacy landscape got a bit more interesting in Brazil with the enactment of a consumer financial data law, which protects consumers' data in financial databases. Some months ago, our major court decided on a trial regarding credit score, also for protection of financial data, decided that it was fair, but it will have to follow some principles. There is, since 1997, a national law regarding a national ID card with biometric data and so on, which are not enforced until now, but it's always a question that will arise many questions, many problems regarding data protection. We have a bill enacted 2 years ago, which dictates the mandatory formulation of databases of people convicted by sexual offense that they are being built in Brazil. And finally, we have the discussion of a data protection bill, which is being prepared by federal government for the last years. And last thing I want to say is that next week, curiously on the International Data Privacy Day, a public debate regarding the Brazilian law on data protection will be opened by the federal government, and the contributions can be gathered from many countries, from everyone in Brazil over the internet and every one of you. Whatever will be the results of the legislative process regarding data protection in Brazil, one aspect of its importance is clear. We are, in a global level, not even near any kind of international treaty or convention in the field of data protection or privacy. In this situation, the consolidation of common rules by adapting and harmonizing several different national laws with compatible approaches and ambitions, and the new elements Brazil can implement, can have an impact on the profile of these common rules. We in Brazil sincerely hope that in International Privacy Day in 2016, we can have something more to celebrate with the results of the debate and the subsequent data protection bill being sent to the Congress for approval. Thank you.
Thank you, Danilo. I'm sure that the audience will have questions on the topic later, about specific questions on this new law called the Constitution of the Internet. But I have, for the moment, a more general question, because I remember you were here 2 years ago. I think that it was here in the Grand Hall too, talking about an initiative which was the bill of the General Data Protection Law in Brazil that was being drafted by the minister. It seems that will have a successful way, but in a strange way, you won't, or for me, we had the surprise this year about this new civil framework focused on data protection and privacy on the internet, was in a very quick way drafted, but no news until now about the general data protection law. Just now this new about the consultation and new expectations. Why the difference? Which are the reasons you think for these different speed timings?
The different timing is on some factual and political reactions on the Edward Snowden revelation, most probably, because when the Snowden revelations were disclosed, it was a very critical time in Brazil for discussing the effects of surveillance and data protection. But at that time, the data protection bill was still a draft kept inside the ministry. So at that period, the law which was vocated that could comprehend in a very quick and fast way an ampliation and extension, including data protection tools, were precisely Marco Civil da Internet. That's why Marco Civil was added, was expanded to include several data protection regulations. But anyway, in a personal opinion, Marco Civil cannot do very much to avoid surveillance, because the kind of legitimacy Marco Civil have does not extend to foreign actors in what could be an effective way, and does not comprehend even internal security agencies. So Marco Civil was a good message to Brazilian people, was established a set of important rights, but the government felt that the need for a general data protection law was still very, very strong. So the different timing between the two.
Thank you very much. Now we will give the floor to Pablo Palazzi from Argentina. We should remember that Argentina was the first country in Latin America with the first data protection law and the first recognition of the European adequacy.
Okay, thanks. I'd like to thank CPDP and Artemi for the invitation, and it's a pleasure to be here. I try to be brief and just comment the main news in Argentina. As already explained by Anna and by Artemi, Argentina has a Data Protection Act with regulations, a data protection agency. It's been acting for around 10 years. We have decisions, sanctions, we have inspections to companies, etc. So data protection is working well and alive. One important piece of law approved was last year, 2014. It's a do not call registry, where people who do not want to receive calls can register their telephone numbers. And the do not call registry, which is in charge of the data protection agency, was approved at the end of last year. The regulation started to be effective 1 week ago, and the government opened a website where people can register so they don't receive calls. And the registry so far has been a success, because in one week only there were 120,000 fixed line registrations and 180,000 mobile phone registration in the do not call registry. We don't have any case yet because this is brand new, but I will let you know next year what happened with the data protection agency. The second news, which I think is important and merits comments, is a Supreme Court case of Argentina that deals with search engine liability or internet intermediary liability. In Argentina, we don't have a notice and take down procedure. We don't have something similar to Section 230 of the CDA. We don't have a Digital Millennium Copyright Act. We don't have a safe harbor as the one you have in Europe with the Electronic Commerce Directive. So there was a lot of questions about what is the status of internet intermediaries using personal data and other issues. And in Argentina, for the last 7 years, there has been a lot of cases of models and celebrities who were suing search engines to take out information from the index of the search engine. And the discussion was first if you could obtain an injunction, and most judges were granting injunctions against search engines, forcing them to take out content from the web. The only exception was for matters of public interest or celebrities. And for example, Maradona tried to clean his record with some issues he didn't want to have on the internet, and he failed because he was a celebrity and people has the right to talk about them. Also some judges or prosecutors, but the rest of the people, common people, were able to clean some information about them. And after the injunctions, lawyers start filing damage lawsuits saying, okay, if I can't take the information, that means because the information was wrong, now I want to be paid for the damage. And several of these cases were cases about the right to one's image. The image is like the right of publicity in the US. It's a personhood right that you have over your image, your likeness, or your voice, yourself, and even your name. And in all these cases, they were using in porn sites the image of these models, so they sue because the image was used without consent. And some of the judges say that the search engine was strict liable, which means that just by scanning the content, the search engine will be liable without any kind of defense. And when this case reached the Supreme Court said that we are not going to impose strict liability on search engines because they are intermediaries. So, but you may be liable for negligence. So first you need to be notified, you need to be served with a notice showing where the wrong is, what kind of information is wrong, why it is wrong. And here the Supreme Court created a notice and take down by court. They said that if you are a search engine and you're notified of something wrong, you only need to take it down immediately if it's a flagrant violation of law. Flagrant means that just by looking at the site, you can determine that that's illegal. For example, a case of revenge porn, a case of hate speech, a case of something which is plainly illegal, and you can judge it just by looking at the website. If you cannot determine that it's illegal, the website or the internet intermediary is protected, and only when there is a judicial or administrative decision, the internet intermediary will be forced to take it down. And here it's important that the court mention administrative decision, but because we all read that the Supreme Court was referring to the Data Protection Agency. And there's only one case so far where the Data Protection Agency has ordered a search engine to take down information. It was a case of a divorce where someone posted very bad content about the other person, and a court said that was fake, and the person claimed to the search engine to have it removed. It was not removed, so he went to the Data Protection Agency instead of going to court, and he obtained an order from the Data Protection Agency of Argentina to have it removed from the index. This was appealed, and on October last year, a district court affirmed the right or the capability of the Data Protection Agency to issue orders to a search engine based on the data protection law, requesting them to remove things from the index. It didn't went into much detail about why they have jurisdiction over a search engine and why. I mean, if you compare the analysis that you find in the Google Spain case with this Argentine case, there's no analysis at all. They just simply say that the Argentine Data Protection Agency may have jurisdiction over this. And well, that's the second case I like to comment. A third case I like to comment, and from Argentina, is a case that confronts personal data, sensitive data, with personal data. In this case, an NGO wanted to access the list of people who were receiving social plans from the government under the Freedom of Information Regulation, and the government rejected to give that information, saying that this was sensitive data. If you're on a social plan because you don't have work or because you are handicapped or something like that, that's sensitive, and the government refused to give it. And this NGO went to the court, and the Supreme Court finally said that in this case, freedom of information prevails over data protection, and they have to give these plans and the list of people who were receiving these plans, because it was money from the government, and people have the right to know how the money is being distributed. From the data protection side, this ruling was highly criticized because we are not talking just of personal data, but of sensitive data. And this data, if it's published, has the possibility to stigmatize people, because it's not the same. I mean, if you're receiving a social plan, if you're not receiving it. But in this case, the Supreme Court was getting a bit into politics and siding with freedom of information and access to this information. And well, I think that's it. I have a comment to case, but some more cases to comment, but I think that I'm running out of time. And, okay, thank you.
Okay, Pablo, thank you. And now we give the floor to the chairwoman of the Mexican DPA, Ximena Puente. I'm sure it will be very interesting. The Mexican DPA is a really leader DPA in Latin America and play a key role in the data protection developments in Latin America.
Thank you, Artemi. It's an honor for me to partake in this session representing Mexico Federal Institute for Access to Information and Data Protection, IFI. As you know, we protect both rights for one hand, transparency, and the other hand, data protection, and to share with you our progress in terms of personal data protection as it currently taking place throughout the Latin American region. Thanks for the invitation, Artemi. During my intervention, I will cover the following two topics. First of all, I will address regulatory development of legislation of personal data in Mexico, and secondly, I will speak about the role of Mexico is playing as a leader throughout the region in terms of personal data protection. In Mexico, regulatory evolution of the right to the protection of personal data has undergone different phases. Initially, in 2002, a federal-wide regulation was provided for the legislation addressing transparency and access to the public information, and personal data protection was regulated with limits. I'm going to say it was identified more as a limit of the right to the access public information. Later, Mexican legislatures argued that the rights involve such a large scope and reach. In consequence, they elevate the rank of human rights provided for the highest level of regulation. And particularly Article 16 of the Political Constitution of Mexico, recognizing that every person has the right to protect their personal data, as well as the right to access, rectification, cancellation, and opposition to use personal data. Moreover, constitutional text reference the principles of this issue and applicable exceptions to the national security reasons, public policy provisions, public security or public health, or to protect the rights to the third parties. On the next phase, in 2010, Congress issued the federal law on the protection of personal data held by private parties, the first law to type for the country's private sector, specifying concrete provisions related to right, principles, procedures, international transfers, responsibilities, and penalties for non-compliance. More recently, I'm going to talk about the recent constitutional reform in Mexico. In February of 2014, a fundamental constitutional reform took place in Mexico. In terms of transparency and personal data protection, which positioned the country's Federal Institute for Access to Information and Data Protection, IFI, as an independent constitutional body, guarantor of the right of access to public information and data protection, which in turn represents greater independence, institutional certainty, specialization, credibility, professionalism, and legal certainty. These reforms provide the issue by the Congress, among the other matters, of a general law of the protection of personal data intended to the law to the groundwork and consistent principles of regulation throughout all Mexico. It's interesting to say that the deadline that the Constitutional set for this new general legislation is on February 7th of this year. We are not sure if it's ready, these new legislations, but we have to wait and see. Mexico is not the only country preparing significant changes in the legislation of personal data. Regulatory developments in terms of personal data protection in Latin America are evolving and becoming increasingly harmonized to be aligned with these requirements of today's technological advances. Allow me to briefly address some of the more relevant changes taking place throughout the region. As I mentioned before, early 2014, Mexico amendment its constitution to consolidate the right of access to information and protection of personal data. Separately, countries such as Chile, Honduras, and El Salvador are currently working on bills of the new set of legislation in the fields. In addition, recent important challenges to legislation have taken place in countries like Colombia, Peru, the Dominican Republic, and Costa Rica. This past November, Mexico was host of the 12th Ibero-American Data Protection Meeting, attended by officials representing data protection authorities such as Chile, Colombia, Portugal, Spain, and Uruguay. This meeting served a backdrop to declare a common intent for actions in 4 primary aspects. First aspect focused on consolidating the network by strengthening its structure, incorporating workout groups, promoting the accreditation of progress of the members and observers, among others. A second aspect focused on promotion international cooperation through these training activities and exchange for information and generating criteria in particular sectors, as well as development to both regulations and jurisprudence. A third aspect, to strengthen a presence of the network in international events related to the personal data protection to be introduced as a cooperation mechanism, encourage good practices, and promoting high standards between countries for safe transfers of personal data information. And finally, a fourth aspect consisting of promoting regulatory progress in the region, whereby as it was agreed to continue collaboration with the Organization of the American States to complete the proposed model of legislation for data protection, which will serve as technical reference preparing efficient and standardized regulatory frameworks among members. During this event on November 2014, and through the Federal Institute for Access Information and Data Protection, Mexico was elected president for a new period from 2014 to 2016. We know it's a very big responsibility for the Latin American region, and we are going to work with all the region to increase the level of protection of data protection in all the countries. Thank you very much.
Thank you, Ximena. I had the chance last November to read the bill of the General Data Protection Law, what was submitted to a consultation procedure, and I remember that there were really interesting topics on the law related to rules on cloud computing, protection of children, privacy impact assessment, strategies, even mandatory DPOs. I don't know if you can share a little bit more about what are the most relevant news on this bill. And usually people, well, we have heard that the Mexican approach to data protection tried to balance, I would say, North American model or approach and European model. How is reflected that in the bill that is now taken to be adopted?
If I made a proposal for this general legislation with all the aspects that we consider that were very important to get into, like computing, cloud computing and principles and procedures, but we are not sure about the final text of the legislations, and we are looking we are looking for the standard and this harmonization to the European standard. So we have to work a lot to get this standard as Argentina and Uruguay.
Okay, thank you very much. And last speech, last presentation from Chile, Paulina Silva, who has been very active drafting the bill of the data protection law, which is now being adopted by the government in Chile.
Thanks, Artemi, and thanks for the organization for having me here. It's a privilege to be sharing this table with these professionals. When I was a teenager and I would gossip with my friends, my mom would always say, if you don't have anything good to say about someone, just don't say anything at all. But since I have to talk about our current data protection law in Chile, I will have to disregard my mom's advice, because I really don't have many good things to say about the current data protection law in Chile. However, there are good news. There is a bill that will very probably soon be presented before Congress that completely changes the face of the data protection regulation in Chile. So in the first part of this very brief presentation, I will tell you about some criticisms that have been made to our current data protection law, and then the characteristics of this very special experience that Chile is going through in these efforts to change this law. So the current data protection law has been criticized under many angles. One of them is for having very wide and clear definitions. The exceptions are very, very poorly drafted. So when you have a law that is not very well drafted, you will want to trust the judges to interpret it, or a data protection authority to fill the loopholes that you will find in the text of the law. But our current law does not provide for a data protection authority, so there's no control there. And since it has a really, really low fines, the enforcement it's not something that has been really tried. There is almost no case law with this law. So what you have is a set of rights, but with no teeth. It's like a wolf that has it's like a puppy. It's something that doesn't bite. You have this animal that could, be subject to enforcement. You have a set of rights, but this puppy, I have nothing against puppies. I mean, I love puppies. But it's a law that does not have teeth to bite, and believe me, there's a lot of meat to sink those teeth into, but there's no teeth. So, our current law dates back to 1999, and this was August 1999, and it was very loosely based on European laws that were enacted in the second half of the 70s and the first half of the 80s. Particularly Spanish law, Spanish Organic Law number 1 from 1982, and French law 1717 from 1978, and the UK Data Protection Act from 1984, which was actually repealed before our brand new law in 1999 came to effect. So when the law was finally passed in August 1999, the laws that it was based on had actually been repealed on those countries or substantially modified. Spain had enacted LORTA in 1992, and then just 4 months after the Chilean law came to effect, Spain also enacted their LOPD. So what I'm trying to get here is that our current data protection law was born outdated. So we have low fines, very low fines. The highest fine that you can get, it's around 3,000 euro. And that has never been imposed. You have a very, very little case law, mostly about wrongful publications in commercial bulletins. So pretty much all the case law that there is in regards to financial and commercial data. So case law hasn't helped interpreting these. And the actual proceedings that you have to pursue in order to take the breaches into court, it's supposed to be a summary proceeding, but it can take up to 3 years. So what you will spend in lawyers, believe me, it's much, much more than the fine that any company could get. So there have been more than 44 bills presented before Congress trying to modify this law and to bring it up to international standards, this time to really bring it up to international standards. There were 2 bills in the last 2 governments that had some extent of success during the discussion in Congress, but then they stopped being discussed for different political reasons. And now there's a new one. So this would be bill number 45. Only that this time, this bill intends to repeal the old law. This is not something that will bring up patches to this failed law or to this puppy law, but will just bring up a whole new structure, mainly based on Spanish law and EU directives. The initiative of this bill comes from the subsecretary of the Ministry of Economy. And what's been very interesting is that this bill has not been presented before Congress yet, but it has been subject to a process of a public consultation in 2 separate or parallel ways. There was this online public consultation where the text of this pre-bill was made public, and the ministry received and answered all comments and questions about every detail of this law. And at the same time, during 6 weeks, a group of experts gathered before the ministry, and I was lucky to be a part of that working roundtable representing the American Chamber of Commerce, the Chilean American Chamber of Commerce. So what was very unique about this process is that the stakeholders sat in a table it was 12 meetings, long, extensive meetings, but their interests were very, very transparent. So we had the chance to deeply discuss this project and criticize it before it even became a bill. So as a result of this whole process, there will be a bill, or apparently there is a final bill, but we don't know the text yet, the final text. And we certainly hope that what comes out after having been discussed in Congress is a wolf with teeth for Chile.
Thank you, Paulina. Let me make a question more. Have you referred to the influence of the Europe or Spanish law in this draft? But Chile is member of the APEC. I would like to know if the APEC strategy on data protection has influenced too in some way in the procedure or in the content of this bill.
Well, not that I'm aware, but I understand that what's been very influential are the OECD privacy policies. And that was one strong reason for Chile to adopt in this pre-bill strong regulations on international data flow. And because that's in our current law, international data flow is not even regulated. So actually, as long as you comply with the authorization standard for any kind of data processing, you're fine with international data flow.
Okay, well, and we have more or less 12 minutes for questions. I would like, in any case, let me add another question, a last. Well, there is just a hand. Then I give the floor, and I will make another question later. Please, can you introduce yourself to know anyone, if you want?
Good afternoon. My name is Frederik Borgesius of the University of Amsterdam. And for years I've been fascinated by one article in the Brazil Constitution. The expression of thought is free, anonymity being forbidden. I was wondering if anybody could elaborate a bit on that. Why is it there? Has it ever been used? Similar articles are there in other Latin American constitutions? Thank you.
In Brazil Constitution, freedom of expression is unlimited, but the privacy is also inviolable, which is in civil law systems. Generally, we deal with kind of balance and ponderation between rights that makes it possible to have such absolute statements of rights. But it does not mean that those rights are unlimited, they are as big as it is possible. No, they are balanced with other rights on of the same category, of same hierarchy. So freedom of speech, privacy, they are all fundamental rights, which doesn't mean that in a particular case they can be balanced and you can come to a conclusion that in some specific ways freedom of speech could be limited. It happens. It's not the same as it happens with the U.S. Constitution when we have a different hermeneutic tradition. But about other Latin American countries, I can ask if anyone else could give a better opinion than me.
Thanks.
In Mexico, the right of data protection is a fundamental right with only a limit of national security reasons, public policy, public security, or public health, or protect the right of the other people. It's very important that the data protection is not the only right. This right has these specific limits, only in cases related with security, mostly.
In Argentina, also privacy is a fundamental right and also freedom of expression, but sometimes you need some privacy to express yourself and some anonymity so you don't fear the consequence of what you said. And I view this anonymity as a way of enhancing freedom of expression. And I'm aware that there was a case in Brazil recently because an app allowed you to send secret messages and a prosecutor issued an injunction banning this app for iPhone, and I think then that was revoked, but I don't know, I'm not Brazilian, so probably Danilo knows more about that.
More questions? Please.
Yes, hi. I have two questions. One about the Brazilian data protection bill. How likely is it that this will be enforced or that this will turn into law? And my second question is with regards to the do not call in Argentina. I work for ASOMAR, the Association for Social and Market Research, and I was wondering if there's an exemption to the do not call for market research.
Regarding Brazil, data protection is not a bill, it's a draft bill. It will be open for public debate. The debate will be on the internet for at least 30 days. The consultations will be made. There will be a new text which will be sent to Congress, but there is no time, no schedule fixed for this. I believe it's most plausible that by the middle or the second semester of this year, the bill could be sent to Congress. But what happens in Congress is something we can only imagine. It can be fast, it can be slow.
The exceptions on the do not call regulations are public good campaigns, election laws, and a third one which I don't remember. Sorry.
More questions? I have, well, then I benefit and I make another question. I don't know if maybe it seems that it's a personal interest, but I wanted to ask Pablo about adequacy, because I think it's an important topic, especially thinking on the European strategy to encourage countries to develop this kind of this data protection right. And Uruguay has just 2 years experience, but Argentina was recognized 2003, I think. You have participated, if I am not in a mistake, in the adequacy procedure in Uruguay. But about Argentina, which assessment, which evaluation can you do for the moment of these long 12 years of experience of this recognition for, the economic point of view and from the protection of data of citizens and data subjects?
Okay. Well, I think it's, the adequacy was very useful. At the time it was rendered, there was a lot of investment from European companies, and probably that helps a bit to have a better environment for work. I'm not sure how much direct is the impact, because I never see numbers saying because there was this, then we increased the number of companies or investment, but I'm sure that call centers are much better situated when they operate under a law which is very similar to the Spanish law, for example. And in my daily practice, when I deal with European lawyers or even US lawyers, and we told them that we are adequate, is like you already know what you're talking about, so it helps a lot to know what you expect. So that's the answer. I don't know really the economic impact because I never see numbers. My guess is it should help a bit, because to harmonize laws always is better.
Some question or comment, please.
Christos Velasco, Protección, Datos, Mexico. I have a question, well, with regards to the adequacy and also with, well, much more with interoperability regarding the APIC cross-border privacy framework and the adequacy decision. I mean, there's this big discussion about like how those frameworks are going to operate. And you made an excellent point, Artemi. I mean, some countries of Latin America are part of the APIC, Chile, Peru, and Mexico. That includes Mexico. And Mexico is also very, very active in APIC. So my question is, like, what is Mexico going to do with regards to the implementation of cross-border privacy rules while protecting the data, well, the data protection as a constitutional right of Mexicans, and to sort of like strike that balance of transboundary data flows and the protection of data protection as a human right?
Maybe I could even specify a little bit the question, Ximena, because former commissioners in Mexican DPA has shared some time with us the intention to apply for the European recognition. Is it the IFI for the moment thinking on it?
Yes, certainly. We start this process in 2013, so we are waiting for the new general legislations to continue with a new impulse to this adequacy process. We have to wait the new rules for this process. So we are very, very, very interested to continue this process of adequacy to the Directive 95/46.
Thank you. I don't know if someone more wants to ask something. Yes. Then last, well, 2 questions, both together, and the answers, and we will comply with the time.
Very quickly, my name is Miguel Recio, I'm a Spanish lawyer. I would like to ask Ximena Moreno, which are the expectations of the IFI regarding self-regulation, as the register is starting this year, I hope. in Mexico? Thank you.
Sorry, can you repeat the question?
Which are the expectations about self-regulation in Mexico? Self-regulation in data protection in Mexico.
And the second question, please. No, I don't know. Well.
Again, to the representative of Mexico, I am very curious about why the IFAI, this agency, refused to challenge the recently approved, terribly done telecommunications law, which authorized unchecked surveillance, basically. So they have the power to challenge it, and they refused. They didn't.
Okay, thank you.
Well, for the first question, in 2010, Congress issued the federal law on the protection of personal data held by private parties. It's the first law that that concerns about private sector and allows this kind of auto-regulation for the enterprises. Is the first consideration. And second, it was a very difficult decision at the IFAI, the plenum of IFAI, and we voted to have or not this kind of constitutional unconstitutional action. It was a very difficult decision, but we made our considerations, and you can see at the internet, at the page of IFAI, which are our consideration for the federal law of telecommunications.
Okay, thank you very much, all of you, for attending the panel, and speakers, of course, for their availability for sharing their presentations and enjoying for all of us all this panel. Thank you.